illegal to kill children during war and conflicts? Atlantic's Graeme Wood said, "Even when conducted legally, war is ugly. It is possible to kill children legally, but the sight of a legally killed child is no less disturbing than the sight of a murdered one." This article was referring to Israel's attacks on Gaza. That's what Wood says. But what does international humanitarian law say? The UN Security Council has outlined the 6 grave violations against children during armed conflict. They are killing or maiming, recruiting or using child soldiers, raping and other forms of sexual violence, abduction, attacks against schools or hospitals, and denial of humanitarian access. Children are considered civilians and must be protected from attacks at all times, and intentionally targeting children is a war crime. So where has the idea that it can be legal to kill children come from? Middle East Eye reached out to the UN Human Rights Office to ask this question. The first thing they clarified is that international humanitarian law doesn't list what is allowed, only what is prohibited. Since October 7, Israel has targeted hospitals, schools, homes, and refugee camps. Over 15,000 children have been killed and over 12,000 have been injured. The UN has condemned a number of Israel's attacks that potentially violate international humanitarian laws. For example, Nasser Hospital and bombing safe zones, which Israeli officials have claimed is a
tragic mistake.
In this mistake in war, a mistake was made.
But there are 3 main principles designed to protect children and civilians from these so-called mistakes. Women, men, boys, girls, and the elderly all benefit from the same protection. The 3 principles are the principle of distinction. This means it is prohibited to direct attacks against civilians unless they are directly taking part in the hostilities. The second principle is proportionality. This rule prohibits attacks where the expected civilian casualties or damage to civilian areas would be excessive or disproportionate compared to the military benefit of that attack. And finally, the principle of precaution. All feasible precautions must be taken to avoid or minimise incidental loss of civilian life, injury to civilians, and damage to civilian objects. The UN Human Rights Office also added that the term collateral damage, which has been used by Israeli Prime Minister to describe the death of civilians at the hands of the Israeli army, is not a term found in international humanitarian law. They said the more accurate term is incidental harm to civilians or civilian objects. Incidental harm is the harm to civilians or civilian objects that result from an attack that was directed at a legitimate military target. They also highlighted that a whole incident cannot be classified as incidental harm.